the court's policy, but notwithstanding, we were allowed that courtesy, and I'd like to thank the court. Moving along to the case at hand, the defendant, Mr. Alexander, through counsel, of course, has filed a written motion to withdraw his plea. The prosecuting attorney having filed a response of the pleading, and I think both parties are familiar with both. To begin, I'd like to address the court rule itself that is at issue here, specifically, excuse me, MCR 6.310D as in David. In my judgment, it seems to be in two parts. One is when a defendant, having pled guilty, the court accepted the plea, and the defendant having then been sentenced, that challenge, as it were, to attempt to withdraw that plea can be addressed in one of two ways. One, whether the trial court erred in determining that the plea was voluntary, accurately, and understandingly made. And as we said in our pleading, we're not arguing that the court otherwise fully complied with the court rule. But the second half, it says that, or any other claim that the plea was not an understanding, voluntary, or accurate one. And of those three, the defendant is claiming that his guilty plea was neither voluntary nor accurately made. Now, the transcript of the plea hearing and the sentencing hearing too, having been prepared and distributed, I'm not here on behalf of my client to argue anything in that is mistaken or false in terms of any of the interactions between the parties. On the other hand, on behalf of my client, as to the voluntariness or the accuracy of the plea, this is essentially my appreciation, understanding that I was not present at the time, nor did I represent the gentleman on that at that time. Apparently, the plea was taken, I'm just looking for my dates. Tuesday, October 6th, 2020 is the date that Mr. Alexander appeared with counsel and offered his plea of guilty to a charge of essentially financial transaction device. And as a part of that plea proceeding, there was an agreement between the parties such that a second charge and a second file of fleeing and eluding police was to be dismissed, as well as some other sentencing agreements that aren't relevant necessarily here. I think that the record would show that this defendant's two files, financial transaction device and the fleeing and eluding, were scheduled to proceed to trial on Wednesday, October the 7th. That would be one day following the day he entered his plea. That is significant for a couple of reasons. Also, what is significant is I included in our pleading as a fact that the defendant contacted either Mr. Watson directly or his office just a few short days following his sentencing, and wanted to make inquiry as to how he could appeal, whether it's his plea or his sentence or both. And subsequent to that, he contacted me and spoke initially of an appeal. And of course, I brought to his attention that he had to go back to the trial court first and bring a motion to withdraw his plea. And so to get to the crux of the issue, given that the matter was scheduled for trial the following day after he entered his plea, it is my representation to the court through conversations with my client that he and neither he and he did not meet with Mr. Watson, nor did Mr. Watson ask to meet with him in terms of any kind of trial preparation. That there seems to have been a bit of pressure, perhaps, put on Mr. Watson, that if the defendant did not plead on the date we're talking about, the matter was scheduled to proceed to trial the following day. I have no idea as to whether there are other cases scheduled, whether any of those other cases may have taken priority. I'm just simply stating that it was scheduled. And let me be clear to both counsel and the court. I've known Keith Watson as long as he's been practicing law. Matter of fact, he and I tried a case together as joint defense counsel. I think Mr. Clinton was president, but in any event, it was some time ago. But I'm not here to cast any disparaging remarks, comments at Mr. Watson at all. I'm merely indicating to the court what has been represented to me, that the offer that was ultimately gotten was made available to Mr. Watson and through him to Mr. Alexander on the day before he pled. So it's my understanding there had not been any offers made for the defendant to consider, that the first and only offer was made just this one day in advance, communicated to him by Mr. Watson. And Mr. Watson, according to my client, indicated that it was either the right thing or a good thing for Mr. Alexander to do, that is to say, to accept the offer. Mr. Alexander is 19 years old. He has an 11th grade education. And his position that he expressed to Mr. Watson is that he was not guilty of the financial transaction device charge. He's in no position to challenge whether a crime was committed, but he certainly maintains that he was not the individual that committed that crime. But in order to take advantage of the offer that was made, it was his understanding and appreciation that it was necessary for him to plead guilty to the financial transaction device, that he had spoken to Mr. Watson, who, best I can understand, it was Mr. Watson who had to convey to Mr. Alexander, what to say and what kind of questions would be asked of him by the court on the record, and that he would have to respond appropriately, or the court would not accept his plea, and thus the plea agreement and sentencing agreement would not go forward. So at that hour, feeling pressured by Mr. Watson, Mr. Alexander was anxious to get the fleeing and eluding charge dismissed, and so he said the words that he had to say in order to make his plea accepted by the court. I think that's what it amounts to. He maintains, frankly, his innocence as to the financial transaction device, that it was not him, that he was not involved. And that he communicated that to Mr. Watson on more than one occasion during the time that Mr. Watson represented him. I appear before the court, respectfully requesting the court to schedule a short hearing on this matter. I'd like to call my client as a witness. I'd like to subpoena Mr. Watson, and I'd like the court to hear the testimony. And based on that and other facts known to the court, for the court then to render a ruling as to whether my client did voluntarily and accurately give his plea. To close, I would comment briefly on the people's response to pleading, that they make it sound as though if a defendant cannot identify an error on behalf of the court in the plea taking process that the defendant's testimony does not supersede or override the testimony he gave to the court during the plea hearing, nor any, affidavit and no testimony by his trial counsel is sufficient. And if I respectfully disagree with that position, I can't imagine what other evidence any defendant, including Mr. Alexander, could possibly bring to the court at this juncture and offer in support of a claim that he should be allowed to withdraw his plea. We have a court rule. The court rule is pretty clear that at least it is possible for one to withdraw a plea even after sentencing. And again, I just ask the court to schedule a hearing so that we can get that testimony and the court can make its ruling one way or another if that would please the court.
All right, thank you. Ms. Carino?
Thank you, Your Honor. Kayla Carino, appearing on behalf of the people. In the absence of a procedural defect in the plea taking process, a defendant must establish a fair and just reason for withdrawal of his plea. But in doing this, he cannot use a post-plea affidavit to contradict what was his sworn testimony. And so that's exactly what the defendant here is trying to do. And that's not law that the people made up or that we're trying to be unfair to the defendant in some manner. That is simply what the law is. That's what applies under these circumstances. And the cases are People versus White and People versus Armistead, as cited in our briefs. So as to the defendant's argument that he should be allowed to withdraw his plea because he had a day to consider the plea offer, the defendant told the court under oath that he had enough time to talk to his attorney about the charge, that he understood the charge, and that he did not have any questions about what was happening. And that's on pages 4 and 5 of the plea transcript. As to the defendant's argument that he should be allowed to withdraw his plea because he felt pressure from his attorney to plead guilty, the defendant told the court, again under oath, that he wanted to plead guilty. He agreed that he understood that if the court accepted his plea, he could not come back and do exactly what he's trying to do in this motion, that is, claim that it was not his own choice to plead guilty. And that's page 6 of the transcript. The defendant agreed that no one used any promises or threats to get him to plead guilty. And again, reiterated for the court that it was his own choice to plead guilty. So for these reasons, the defendant has not established a fair and just reason to withdraw his plea. And the people would request that you deny the defendant's motion to withdraw his plea.
Thank you. The court goes through a somewhat lengthy process when taking a plea where I have to ask the person pleading guilty multiple questions. Sometimes people seem like they just want to get through it and they don't understand why I'm asking them all of these different questions. And some of them sound like I'm asking the same thing in different ways. The reason I do it is because, one, it's required under the court rules, and two, I'm trying to impress upon the person pleading guilty that you can't just come back later and say, I changed my mind. You can't stand there and answer the questions and say, yes, I've had enough time to talk to my lawyer. No, I don't have any questions about what we're doing. No, no one has coerced me or forced me or threatened me to do this. And yes, I'm doing this of my own free choice. And yes, I'm doing it because I believe that I am guilty. You can't go through and answer all those questions and then just come back later on and say, actually, I didn't mean it when I said those things, or I changed my mind. And I cover that as well. You understand you can't come back later on and say that it really wasn't your own choice to plead guilty. Yes, I understand that. So I covered this in multiple ways when I took the plea. And the defendant's acknowledging that there was no defect in the plea taking process, but they're merely just saying now, well, but we really didn't mean it. So there is no basis. This is not a legal basis for withdrawing a plea. And none of the grounds have been met. And I am denying the motion to withdraw plea.
I'll prepare an order.
All right, thank you. That's all for the record. I have to take a very brief, maybe 5-minute break here. If everyone could just stay in place, I will be right back.
Ms. Carino, 7 days. Is that okay with you?
Pardon?
I say a 7-day rule for the order. I'll prepare an order.
Yeah, feel free to just email it to me if that works for you.
Okay,
Thank you.
you bet. Thank you. Good to see you again, virtually.
You too. Thank you very much. Have a good day.
You bet.
That was for Mr. Shear, just disclosing that he's got a condition that may cause some coughing when you get to that plea.
Yes,
Or-
thank you.